Hello and welcome to the Husch Blackwell Labor Law Insider. I'm Tom Godar, your host, and I'm excited to share with you the developments in labor and employment law that we're seeing across the board, and particularly through the National Labor Relations Board and its General Counsel Abruzzo. When President Biden was elected, he said he was going to have the most employee and union-friendly administration ever, and he has fulfilled that pledge. I have HB colleagues and others who are thought leaders around the country taking a look at some of the issues challenging employers and giving them pause for consideration and maybe making some changes in their own workplace. So as we move forward on our Labor Law podcast, get ready, buckle in for a wild ride exploring the Labor Law Insider. It's great to have you join us once again for the Labor Law Insider. I'm recording this after we did the complete recording of our conversation on this very practical approach to labor law issues that are coming up because of the changes in the NLRB and the interpretations offered by the General Counsel for the NLRB. As I told you, if you had the pleasure of listening to the first recording, you're going to hear my voice a little bit muddy. I made a little glitch here with a different kind of microphone than we'd normally use. So it's not going to sound quite as crisp as this sounds, but you're going to enjoy it. And we're going to pick up where I'm asking a question about a fellow that I've decided to call Wile E. Coyote. And he's causing all sorts of headaches for the employer. And as I ask the question, it really is a carry-on of the scenario we set up with Wile E. Coyote has created some chaos for the employer, but the employer may have only limited tools to respond because of the National Labor Relations Board. So let's pick it up right from there.
That's great. And so we have to be aware that this scenario, as I'm trying to roll it out, this person, call him Wile E. Coyote. Wiley was potentially a low-level 211 supervisor, but we'd have to be really thoughtful because let's assume that Wiley was engaged in some of these behaviors along with somebody who was clearly not going to be identified as a supervisor. Together, they're making it hard for other people who work in this scenario in the group home. Together, they're making fun of the common boss, maybe the area manager or director. And together, they're posting stuff on Facebook. They're using curse words to describe her or him. And Wile E. Coyote maybe is a supervisor, but Willie, employee, is not. How does that play out when we've got two people engaged in similar activities? We have similar policies, but one's a supervisor and one's not. Can we discriminate between the two of them because of their status?
Yeah, you can. As a practical matter, though, I think I'd be very careful in doing that because what I would also want to know is, are these individuals who have any credibility in the workplace? Are they, more or less viewed as having some sort of leadership role so that employees will look to them in terms of how to react regarding conflicts in the workplace? And so regardless of whether you might be able to discipline the supervisor, I think you got to be careful if you don't want to make a martyr out of somebody. And it's going to be looked at very strongly by the workforce as, hey, wait a minute, how come Supervisor A is getting disciplined, but they're not doing it to employee B? Is this favoritism? I mean, they're not going to look at it from a technical standpoint, whether there's a supervisor or not. They're going to look at it as maybe someone's playing favorites. I mean, going down a path you don't want to go down.
Well, in most of our conversations, don't they include at one point in time either the client saying to us or we inquiring of the client, what kind of protected characteristics does the person have, and have they raised issues regarding retaliatory or discriminatory action based on their characteristics? And so what if Wile E. Coyote is 55 years old and has a disability or is a minority? Does that make the analysis more difficult?
Yeah, absolutely. I mean, you've got to be careful. I mean, we've been talking about protected concerted activity under the NLRA, but as you know, there are other protected categories you have to be aware of too. And I think that's a very smart suggestion on your part, just to be more aware in general regarding protected categories.
Well, this is a little bit frustrating for the client now. The client says, you mean I can't do anything about them breaching our confidentiality policy? And assuming for a moment we're not using the analysis that this person's a supervisor. And I can't do anything about sharing confidential information beforehand, but I am very concerned because of the fact that they were also sharing compensation information. They were trying to weasel compensation information out. They're hassling people about how much they got paid. We have a policy that says you don't discuss that kind of activity at work. And it just makes everybody uncomfortable. And frankly, people are hired at different times. They come in with different skills. And we're not about to sit down with every employee and say that each time we hire somebody, this is why somebody got $1 more or less an hour than somebody else we hired within the last 6 months. And so they're really creating an upset within the workplace. Is that a good enough reason to continue down this path of discipline?
I'd say likely not when it comes to, the discussion or the sharing of wage information amongst employees. Wages, terms and conditions of employment, that's the phrase used specifically in the Act. Employees do have a right to discuss that and to discuss that openly because PCA and the NLRA, the statute really protects employees and enables them to help kind of better their status as a lot, right? To work concertedly together to improve their working conditions. And obviously wages being, probably the most important working condition to most employees, right? How much they get paid and, what they could do and afford to live. So by openly discussing that, yes, it could be frustrating to an employer. I would tread very carefully to take any adverse action or admonish an employee for doing so, because really that is, one of the basic tenets of protected activity under the Act.
Yeah, discussing wage information, discussing terms and conditions of employment, discussing hours, that's sort of in the middle of it. And while in the past there was a certain amount of incursion, if you will, into some of those areas of discussion, I think it's frankly wide open. You can talk about any of that at any time, and even in a sort of gross and, shall we say, combative way with supervisors or even inside the sort of public airstream of the World Wide Web. Terry, is there a whole lot of contours that would slow down employees in discussing these things?
This has been an issue that's been around since I was a board agent. And discussing your wages in particular is such a protected conversation from the NLRB standpoint. You can call up the greenest of NLRB agents on the phone and ask him whether or not an employer can discipline an employee for improperly discussing their wages with another employee. And they will immediately say, oh, yes, that's unlawful. No question about it. Come down and file a charge and we'll push that for you. And that really hasn't changed over the years. I mean, that's just one of those fundamental issues that has been in place for so long that, it's really not subject to debate anymore. So, yeah, you've got to be very careful with those issues and not walk into a situation that's going to get you involved in a lot of litigation. And that's the problem, is that you have would appear to be a minor misstep, result in a charge, results in an investigation, will result in a hearing before an administrative law judge, can result in an appeals hearing before the full board. And all of a sudden you're spending all this money, which could be used for other purposes. And it's based upon the actions of one employee, and make you go down this road you really weren't anticipating and start stirring the pot in the workplace. It's not a good situation.
Well, in this case, as we keep pushing the scenario one or two steps before I let you guys go, in this case, as I suggested, there's residents, clients, patients, somebody that is being cared for in one way or another. And these folks are beholden not only to the organization, our employer, that we're discussing in this scenario, but there are others to whom they can complain, whether it's the state or insurance company or who knows what. And so the complaints come against a Wile E. Coyote too. The Wile E. Coyote uses them to, get their cigarettes or withholds food as punishment and stuff like this. But it's all within this context of these other activities as well. That is complaining about wages. That is using foul language when they're doing so. That is recording conversations, which might be a violation of a policy. how does this sort of other stuff come in? I mean, how do you filter it for the client, or how does the client filter and says, yes, we'd like to terminate you or discipline you for this other stuff, but we're just going to keep it really narrowly focused? Are we able to help clients focus that way? And might we still find ourselves being challenged, even if we try to say in the termination or discipline documents it's narrowly focused, that they're going to say, no, we also heard that you're unhappy about this or that or the other thing that might implicate the service cycle or other decisions that go to protected and concerted activities? I know that's convoluted. Anybody want to take a shot at it?
I think as attorneys that, we represent employers, we deal with this type of situation often, right? The facts are never usually perfect. And I think it's as long as we're able to articulate a legitimate business reason that is unrelated, to the alleged protected activity, we stand by those reasons. We are here and we don't want to hamstring our clients and employers. And, the board and the state of the NLRA and the state of, the board makeup already makes that difficult to begin with. So to the extent the issues get muddled, I think we just have to do our best to demonstrate. And that's why we always advise clients, maintain proper documentation, why you're taking this action. Don't just spring the termination after now they've already engaged in the PCA. So now really, what is the true reason for doing so? So I think ultimately employers can't be too fearful to take action when necessary. And obviously, if this person is acting abusive towards clients or residents, that's extremely problematic. Those are just my thoughts as to that type of situation.
Yeah, I think for me, it gets down to training and having a pause button. In most of these situations, there's no need to rush through the disciplinary process. If you're unsure or think there may be some legal issues involved in discipline, hit the pause button. Call up somebody more senior if you're uncomfortable with the decision-making process and discuss it with them. Contact your labor attorney. It won't make a big difference in most cases if you just hit the pause button and wait 24 hours or 48 hours before you step forward. 2, training. There's no need to train your first-line supervisors to be labor attorneys, but there are certain hot topics that you can cover with them. But more importantly, the senior HR person on staff needs to know these issues fairly well. And so they should be getting the necessary training to understand what are the hot buttons. When is it that I should be picking up the phone and talking to senior HR folks or our attorney regarding, well, we've got a situation here. We think it's a bit dicey and we need some assistance. Because again, what may appear to be once very small disciplinary action being taken against one employee can result in a landslide of activity impacting all the employees in the workplace.
Well, and that was one of the best parts of this scenario. The pieces of it that were truthful, that happened in sequence to just one employer. But that is that the client called while the employee was on suspension, right? In this scenario, they were asking for advice, right? They were saying, okay, and they went, oh, you mean that's out of we can't use that? Oh, maybe we shouldn't use that. Oh, our policy might be flat on that one. But we could still try to discover whether or not out of this whole soup of activities, there were some that would stand on their own, that you needed nothing else in order to justify discipline or possibly a termination. And so I love your idea of a pause. And for this, when you come across this, it's not unusual for any of us, I'm sure, to say, folks, let's take a look at your handbook, whether we do it or whether you have someone else do it who's qualified and capable. But I almost invariably suggest, whether we do it or someone else is, that training follows with that management cadre to walk through the handbook and to talk about why those changes were made. They give an opportunity for the employer to touch a whole bunch of people, whether remotely or directly, if people gather in one place, about what should we be doing with time off policies? What should we be doing with disciplinary policies? How do we deal with this type of behavior or that type of behavior? Because honestly, Terry, as you suggested, just going through the policies and making sure that they could stand up to board scrutiny without the training doesn't really get far enough, at least in my estimation. What do you guys think?
Oh, yeah. I mean, you're absolutely right. You got to have both. You got to have the training and you've got to do the legal review to make sure the policies are in line with current board understanding of what's protected and concerted activity and knowing, again, right now, just the general atmosphere at the board and the aggressive nature that they're going out and prosecuting these cases might seem the most minor of violations. But you've got to be very careful right now, at least until there's a change in administration. So we have somebody else in there being the general counsel for the NLRB, because she's taken an extreme position on everything. And so you just got to be careful.
Mm-hmm.
And I think it's important, I did a recent training on handbooks for a client, and the first thing that we discussed, and it seems obvious, especially for the high level HR or managers who are, the brainchild behind the discipline or dealing with employees, is, you have to not only know the handbook exists, but read it, familiarize yourself with it so you understand it. It's not just, oh, here legal, make the necessary changes, put it in a drawer and forget about it. There's real life consequences now when it comes to these policies and implementing them in a lawful manner, as well as making sure that the language in and of itself is lawful. So it's just, hammering home that you can't just forget these exist. You have to understand them so you know how to implement them going forward.
Those are great thoughts, man. I have so much respect for those folks in the organizations that we have a pleasure and honor to represent, who take on this HR role, this labor role, because there's so much going on. And each employee brings with him or with her a whole potential list of issues. And the world doesn't get easier. This week, our colleagues did a fantastic job of writing about two more issues, not National Labor Relations Board or ACT stuff, but whether all or nearly all prohibitions on restricted activity following employment in the terms of a non-compete are illegal with this, the signing of an executive order, or whether with the signing of an executive order, 20% of all of the folks who are now getting paid on a salaried basis as an exempt employee might have to look at whether or not their wages are high enough to qualify for that exemptions. So this isn't the only thing that our wonderful HR clients are looking at. There's just a whole world of stuff that they have to face down. It seems these days almost on a weekly basis. So let me just give you folks in that world an attaboy and an attagirl. You're doing fantastic, but it is difficult, and we appreciate that.
Yeah, I agree. I can't imagine at this point in time, with all the decisions HR has to make on a daily basis, it's a lot of pressure. It's a lot of pressure.
Well, Mary Ann, Terry, thank you so much for joining in this sort of practical application of what we're seeing, what our clients and friends are seeing out in the workforce, how, the crazy scary cycle decisions and the announcements and pronouncements of the General Counsel for the National Labor Relations Board are impacting day-to-day activities. So we'll continue doing these labor law insiders because we haven't found yet that they're not needed. Mary Ann, thank you so much for joining us.
Thank you for having me.
It was great. And Terry, always a pleasure to have you join us on the panel.
All right. See you soon.
All right. Take care now. And thank you for joining the Labor Law Insider.